So, welcome. Thank you for joining us for today's webinar, Amplified Recruitment, Harder, Better, Faster, Stronger. How to use AI in recruitment lawfully and ethically. My name is Nicola Cain. I am the CEO and Principal Consultant at Handley Gill Limited, which is an award-winning legal and regulatory compliance consultancy with specialisms in data protection, responsible AI governance, content regulation and online safety, information access, responsible business, and human rights. The title for today's webinar, Amplified Recruitment, Harder, Better, Faster, Stronger, was inspired by Daft Punk's lyrics. Work it harder, make it better, do it faster, makes us stronger. When undertaking recruitment, we are usually not merely looking to fill a post just as quickly as possible with any old candidate, but to appoint the best person for the job within a fixed time frame. Ensuring that we use AI in recruitment in ways that not merely enables us to do the job faster, work it harder, but to make it better and make us stronger is absolutely crucial. The rules on the use of AI and automated decision making were actually relaxed earlier this year in February 2026 as a result of amendments to the UK GDPR and the Data Protection Act 2018 introduced by the Data Use and Access Act 2025. Now, interestingly, according to research published by the Data Protection Regulator, the Information Commissioner, just last month at the very end of March, many controllers were not only not complying under the old rules, the use of AI in recruitment was not fair, it was not lawful, it was not transparent, and data subjects were not being afforded their rights. But applying the ICO's findings even under the new relaxed rules, the use of AI in recruitment by many organisations is still taking place unlawfully and without appropriate safeguards, exposing organisations to reputational, regulatory and litigation risk and preventing them from actually achieving their aim of getting the best person for the job. A key question is whether controllers are actually able to recognise when they're conducting solely automated significant decisions in the context of recruitment and then are complying with the relevant rules in relation to that. So, in order to help you make sure that you're doing the job right, the content of today's session, we will look at the opportunities to adopt AI in the recruitment process. We'll talk a little bit about the sorts of things you could be doing, the risks of adopting AI in the recruitment process, data protection basics when working with third-party tools, so going through how some of the rules, the general rules, will apply in the context of AI and recruitment, how to comply with the new rules on automated decision-making, how to identify and mitigate the risks of bias and discrimination, how to implement responsible AI governance measures, what the implications are of the failure to comply with these requirements, how to identify solely automated decision-making by looking at several case studies. So, first of all, what are the opportunities to adopt AI in the recruitment process? There really is scope to adopt AI at every stage of the recruitment process, from writing a job description to communicating with candidates to actually determining the outcome of a recruitment process. Some of the examples we've seen are using it to draft or to target the advertising of particular job adverts to potential candidates, to sift applications to determine whether applicants meet mandatory minimum criteria or legal requirements, such as having the right to work in the UK, to score competencies and skills, and to rank candidates with a view to determining who should be rejected and who should be identified for further consideration in a process, to identify an ideal candidate by reference to existing workers, to require candidates to conduct an initial interview via chatbot, which scores their communication, to transcribe and summarise interviews using AI, to conduct asynchronous video interviews where AI is actually the interviewer, to detect a candidate's emotions or evaluate their language, tone, content of what they say, with a view to predicting their personality and their fit with a team or an organisation. Using AI to draft and actually do candidate communications, And even implementing agentic AI workflows where several of these measures are kind of tied together and being acted upon and carried out by the agentic AI. It's important to bear in mind, however, that just because AI can be used and is being used doesn't necessarily mean that it should be used. AI does have the potential to actually reduce bias and discrimination, and can enable recruiters to focus their energy and expertise on making judgments about candidates rather than doing administration. So there are definite opportunities to using AI in the recruitment process, but there are also risks. So while scientific research demonstrates that humans are biased, we all have inherent bias, and AI has the potential to cut out that bias. Depending on how AI has been trained, the criteria being used, how it's prompted, it has the potential to perpetuate or to amplify existing bias in society. It can result in you failing to identify the best person for the job. It can result in a failure to comply with legal and regulatory obligations, whether that be data protection, equality, or human rights. It can result in damage to reputation. It can build distrust in technology. And it can result in a breach of trust and confidence between an employer and their existing employees if they see poor uses of AI. The Information Commissioner identified the use of automated decision making in recruitment as one of his priority focus areas in the June 2025 AI and biometric strategy, and with a focus with an aim to ensure that automated decision making, or what the ICO now calls ADM, systems are governed and used in a way that's fair. The UK's rules, as I mentioned, have got easier. It's interesting to contrast the position in the UK versus the EU. As a result of the EU's AI Act, AI systems to be used in recruitment, whether that's to place targeted job ads, analyse and filter job applications, or evaluate candidates, are classified as high-risk systems. That's something worth bearing in mind when you're thinking about what is the risk of doing what we're doing and of using AI in recruitment. Certainly in the EU, they would consider that to be a high risk unless you can demonstrate that your system doesn't pose a significant risk of harm to the health, safety, or fundamental rights of persons, including by not materially influencing the outcome of decision making. And from August 2027, if you are producing or using one of those high risk AI systems, then there are additional obligations you have to comply with. So what are the data protection basics if we're working with third-party tools? There are a number of measures. Obviously, we're not going to go through every single requirement of data protection law in the UK, but we're just going to highlight some of the key measures that you'll need to think about, particularly when you're thinking about using third-party tools, such as AI tools in the course of recruitment. From fair processing, having a lawful basis, being transparent, conducting a DPIA, putting in place a data processing agreement, reviewing and making sure any restricted international data transfers are compliant, being able to comply with data subject rights, thinking about your data retention, and also implementing appropriate data security. So fairness. Fairness in the context of data protection means using people's personal data in ways that they reasonably expect and not using it in ways that cause unjustified adverse impacts. In the context of the use of AI in recruitment, then, what does fairness mean? What does that look like? Well, in its recent report, the ICO called for the adoption and expansion of monitoring for fairness and bias in the context of using AI in recruitment, and called on controllers to either make sure they're obtaining appropriate information from a developer or to conduct their own testing for fairness of systems. You're likely to need to think about, so testing, does the system work? Does it do what it says it should do? And does it do that in a way that's fair, so non-discriminatory? And in this regard, if a system fails to comply with other requirements, like requirements for your legal obligations not to discriminate, then if it is in fact discriminatory, then that will fail a fairness test. And in addition to testing prior to using a tool, the ICO has also said it expects there to be ongoing monitoring and has said that a failure to review AI recommendations periodically for accuracy, bias, or fairness and the effectiveness of human involvement is likely to be unfair processing. As to the accuracy of the system, does the system work as intended? And insofar as any personal data is being inferred by the system, that those inferences are accurate. So when we think about things like emotion recognition, for example, or where you're trying to predict a personality type, are those predictions and assessments, are they actually accurate? In its biometrics forensics report, for example, the ICO noted that emotion recognition technology may reveal highly sensitive data via subconscious behaviours and responses, which may be interpreted through what it described as highly contested forms of analysis, and that those risks may be amplified in the workplace. And they raised caution that as to the ability of algorithms to accurately detect emotional cues, in particular for ethnic minorities, those from non-European cultures, or neurodivergent individuals. The Deputy Commissioner, Stephen Bonner, issued a statement at the time and warned that developments in the biometrics and emotion AI market are immature. They may not work yet or indeed ever. And as it stands, we are yet to see any emotion AI technology develop in a way that satisfies data protection requirements. And we have more general questions about proportionality, fairness, and transparency in this area. So clearly, accuracy in the context of fair processing, if you're going to look to use exotic AI techniques and tools, that's something you need to be really wary of. Does it work? Does it do what it says on the tin? You can't just take what a vendor is telling you. You can't just take their word for it. You've got to do the regulatory expectation is that you will do your own assessment and analysis. That might be based on the information they give you, but you can't just say, well, the sales pitch is this is what it says it does. You'll also have concerns around confidentiality of data and restrictions on reuse, whether by controller to further kind of scope the ideal candidate or by third-party providers. If third-party providers say they want to use the information you input into their AI system for training their AI, for example, that's going to impact the fairness of its use. In addition, for processing to be fair and compliant, candidates must be able to exercise their data subject rights. And insofar as your processing does involve solely automated decision making in a way that's that falls within the scope of Articles 22A to D of the UK GDPR, you'll also need to be able to give them to enable them to exercise the right to contest decisions. And failure to do that will not only be a breach of those provisions, but will also have a secondary impact on whether your processing is deemed to be fair. Your lawful basis for processing. Prior to the Data Use and Access Act 2025 coming into force, if you wanted to do restricted, solely automated decision making, you had very few lawful bases on which to rely. You could only rely on contractual necessity, consent, or that the processing was authorised by law, and that you had a lawful basis. None of those were readily applicable in the context of using AI in recruitment. The ICO in its report said it was often unclear which lawful basis employers were relying upon for automated recruitment and at which stage of the process they applied this basis. Many employers relied on consent and/or contract, which are unlikely to be an appropriate basis for processing personal information in most recruitment contexts. So already we can see that if you were an employer or potential employer of a candidate using solely automated decision making in the way that's restricted by the UK GDPR, in reality, the ICO's position is that most employers were doing that unlawfully. However, since the February 2026 changes came into force, controllers are entitled to rely on the legitimate interest lawful basis for automated decision-making and recruitment. They will need to go about conducting legitimate interest assessment or incorporating that into a DPIA, for example. But there is now a lawful basis which enables this to be conducted. So if you weren't already doing it, you may now be able to do it. If you are already doing it, it's probably a good time to revisit your DPIAs, your ROPAs, your privacy notices, and make sure that your lawful bases match the new lawful basis you're entitled to rely on and are consistent with the ICO's report. And as I say, this reason it's a report, it's a status update, but there's actually quite a lot of useful guidance and new guidance in there. So it's worth looking at. Transparency. You'll all be familiar with transparency requirement. Articles 13 and 14 of the UK GDPR require transparency of processing of personal data. The rules are slightly different depending on whether personal data is obtained directly from an individual or from a third party. But you do need to tell them purpose of processing, lawful basis, categories of personal data, international transfers, their rights. And there are also already requirements that if you are undertaking restricted automated decision making, you have to tell people that that's happening, and you have to provide them with meaningful information about the logic involved and the significance and envisaged consequences of those decisions for individuals. In recent weeks, in its report, transparency was identified by the ICO as an area requiring improvement. When using AI in recruitment, it's an area it has already addressed with some controllers, and it is continuing. It said it will continue to engage with controllers in relation to this. This is not the end of the road. It's on a journey in relation to its enforcement in this area. The ICO highlighted that most privacy information we reviewed wasn't specific enough to sufficiently inform candidates about how their personal information was being processed or about even the very fact of the use of automated decision making. DPIA, you're required by Article 35 of the UK GDPR to carry out a DPIA prior to commencing processing, which is likely to result in a high risk to the rights and freedoms of data subjects, particularly where that processing involves the use of new technologies. A DPIA will be mandatory where processing involves a systematic and extensive evaluation of personal aspects relating to individuals based on automated processing, including profiling, and on which decisions are based that produce legal effects or similarly significant effects. So if you are doing restricted, solely automated decision making, you must do a DPIA. AI in recruitment is likely to require a DPIA to be carried out. The ICO pointed out in its recent report that not all employers who were doing automated decision making had completed a full DPIA prior to commencing their processing activities. Those who had, often it pointed out they just hadn't done a proper job of their DPIA. A DPIA must be appropriately thorough. It's no good just saying, oh, we've done a DPIA if it's not really worth the paper it's written on. It has to be thorough. It has to consider the risks appropriately. But the ICO recognises, and in practice there is a challenge often in obtaining the necessary information from your AI tool developers to actually do your DPIA. You need an understanding of, how the system was trained and prepared, how it works, what are the criteria, and often developers consider that to be the secret sauce behind their tools and don't want to disclose that information or only want to disclose it subject to an NDA, which kind of can work, but obviously when you've got a DPIA for your public sector organisation, that some of that may be disclosable under FOI. You could potentially try to withhold some of that information, relying on confidentiality exemption, but then there are balancing tests to be carried out. If you're a private sector organisation, you'll still be required to disclose that to a regulator in the course of litigation, for example. So you'd have to have appropriate carve-outs. And if you've got a DPIA that so much of it is kind of redacted essentially when being disclosed to someone else, so that they can't actually understand it or make sense of it or understand the risks and the risk assessment, that's really probably not going to be good enough. You should also have, if you're using a third party, you're also going to have a data processing agreement in place. That's required by Article 28. 3, and there are certain mandatory requirements as to what's going to be in that agreement. You're also required to take steps to assure yourself as a controller of the suitability of your processes. They offer sufficient guarantees to implement technical and organisational measures to comply with the regulation and protect people's rights. So again, we're coming back to this idea of you need to understand. You can't just take at face value what vendors are telling you, what you hear from your suppliers. You need to do your own testing and assessment, whether that's based on the information they provide and or doing your own testing. And we'll talk a little bit more about what that testing might look like later on. And those I've just highlighted there on the slide, some of the requirements. One thing, when you're doing your data processing agreement, lots of vendors will have standard terms that will grant them permission for them to reuse personal data for AI training purposes. That can be really problematic. While there has been a recent relaxation of rules on reuse of personal data, including, and some of those rules could apply to technological developments when it's transferring that essentially to a third party in order to enable them to do that. You'd have to be clear about that in your privacy notice. It would have to still be fair. They would have to have a lawful basis. You need a lawful basis for doing the transfer, etc., etc. It's quite a lot of additional work for you to consider whether that's appropriate. If you can avoid disclosing that information for those purposes, that would always be the better thing to do. And if not, and it's a requirement of a vendor that you let them reuse that data, then you're going to want to consider carefully whether that's an appropriate vendor for you to work with. You've then got restricted international data transfers. Often your tool provider is going to be based outside the UK. If that's the case, then there's likely to be a transfer of personal data, even if they say that they are going to store the data in the UK or the EU. If the provider is outside, if they're established outside the UK, their head office, the contracting party is outside the UK, there will be a transfer for the legal purposes. That means you're either going to have to comply with adequacy regulations. So, for example, if it's a US company certified to the EU-US Data Privacy Framework and the UK extension, that would be okay. Otherwise, you're going to have appropriate safeguards, which in the context of using AI in recruitment, it's likely to require you to have your data processing agreement supplemented by standard data protection clauses, either in the form of the ICO's International Data Transfer Agreement or the addendum in conjunction with the European Commission's SCCs, the modernised version of those. It's worth noting that the threshold for conducting a transfer has been lowered by the Data Use and Access Act 2025, which has introduced Article 45B of the UK GDPR, whereas previously, like in the EU, the standard was an essentially equivalent level of protection. The standard is now a not materially lower level of protection, and you have to have regard to a narrower range of factors. So, for example, while you have to give consideration to whether there is an appropriate regulator and what powers they have, that's the same in the UK and the EU. In the EU, you would also have to have regard to how effective they are. Are they actually using those powers? Are they doing enforcement? Where in the UK, that's no longer a requirement. While in theory, you could also do a transfer on the basis of a derogation, at Article 49, they're unlikely to apply to AI in recruitment and transfers on that basis. You've then got all the usual data subject rights, the right of access, which includes the right to be provided with meaningful information about the logic involved in a system, significance and envisaged consequences for individuals. That can be a challenge. You need to think when you're looking to buy these tools, is the developer provider willing to provide you with the information to enable you to comply with this? Right to rectification of any inaccurate personal data, so particularly around inferences, inferred data, is that accurate? Right to erasure in respect of certain data where it's unlawfully being processed largely, but there are other grounds. Right to restrict processing where it's being challenged. And a right to object to processing based on legitimate interest, which this is likely to be in the context of AI in recruitment. You are going to be relying on the legitimate interest lawful basis. Individuals are entitled to do that. So you've got to think, what is your fallback going to be? if to make that meaningful, as well as providing or generally using AI to conduct elements of your recruitment process, you need to provide an alternative because people are entitled to object and not to be penalised for doing so. As to data retention, Article 51C of the UK GDPR is the data minimisation principle. So your data is going to be adequate, relevant, and limited to what's necessary in relation to the purpose for which data is processed. Articles 13 and 14 entitle individuals to be informed how long their data is going to be retained or the criteria used to determine that. Often in recruitment, an option will be given for individuals to give their consent to the retention of their personal data beyond its use in the context of the specific job for which they've applied. That shouldn't be completely open-ended. 6 to 12 months is pretty common. I have seen, and I think it could be justifiable depending on the nature of the role, the types of individuals you're recruiting, then you may be able to have longer periods than that, but that's something you'll need to think about. Data security, something you're all familiar with. Basic requirement requires controllers and processors to implement appropriate technical and organisational measures to ensure a level of security appropriate to the risk, including the risks of accidental or unlawful destruction, loss, alteration, unauthorised disclosure or access to data transmitted, stored or otherwise processed. So these are ideas of confidentiality, accessibility, integrity of data. Confidentiality is particularly important. And again, when we've talked about if you've got providers who want to be able to use data for other purposes, potential issue for you and your ability to comply with these requirements, you need to consider it very carefully. So the rules on automated decision making. The rules are restrictions under the UK GDPR and Data Protection Act 2018 as amended by the Data Use and Access Act 2025. As I say, there was a change in February 2026. We're going to talk about the post-February 2026 position. The rules apply where there is a decision. That decision is significant in the sense of having a legal or similarly significant effect. The decision is based wholly or partly on personal data, and the decision is solely automated, which means that there is no meaningful human involvement. And if you want to do automated decision making based, whether in whole or in part, on special category personal data, there are some additional restrictions that apply there. Correctly identifying when restricted solely automated decision making is taking place is the first challenge. And the ICO in its report highlighted that many employers didn't consider ADM was taking place when the ICO's view was that it absolutely was. So the ICO's report this is the report on fair and responsible use of automation in recruitment, said that whether employers use automated recruitment tools to make or to support recruitment decisions, data protection law generally applies. Where they are used to make decisions, the specific legal protections that govern the use of ADM will apply. And when you're doing restricted solely automated decision making, safeguards are required. And obviously all processing is subject to compliance with data subject rights. So what's a decision? It's a pretty broad concept. The ICO draws a distinction between the application of rules and analysis. So a decision is a conclusion or outcome reached after consideration or analysis, which may impact or influence actions taken or engage a data subject's rights. The ICO highlighted that in the context of decision making, if you were using an automated system built to filter out candidates who don't have the necessary rights, qualifications, or skills, that is enforcing a static rule. So, for example, do you have the right to work in the UK? Yes, no. If you need the right to work in the UK, the answer is no, and use an automated system or AI to say, right, all the no's we're going to automatically reject. That is a binary consideration. It's enforcing a static rule. That is not a decision for the purposes of UK GDPR. The ICO noted that issues became most apparent when people are rejecting unsuccessful or unsuitable candidates and not properly recognising that that constitutes a decision. There's a difference between those kind of binary rules and something that has more analysis. But then the decision has to be significant, so it has to have a legal or similarly significant effect. A decision with a legal effect is one that affects a person's legal status or legal rights. A decision that has a similarly significant effect is one that has an equivalent impact on someone's circumstances, behaviour, opportunities, or choices. The ICO's position are set out in its headline for it was the Recruitment Rewired report, was that rejecting a candidate is capable of constituting a significant decision, and the restrictions on automated decision making will apply in the absence of meaningful human involvement. And the ICO felt that from its research, many organisations are simply failing to recognise that their decisions, particularly in the early stages of a recruitment process, constitute significant decisions. So a rejection, even after an initial sift, the ICO's position is that is a significant decision, if that's based on analysis. If it's just based on those binary factors, do you have a degree, if we require a degree, or, do you have the right to work in the UK? That wouldn't be a decision or a significant decision for the purposes of the UK GDPR. Doing an analysis of someone's CV, their qualifications, their experience, that would be. But then the decision has to be solely automated, so lacking in meaningful human involvement. Meaningful human involvement must be more than a token gesture or a rubber stamp, and it has to be built in at every stage of the process as to whether to progress a candidate. The ICO says that to avoid your decision being considered to be solely automated, there must be a human to assess and review the decision at an appropriate point to ensure they have an actual impact on whether a candidate is selected or eliminated, have the ability to influence that decision, have the discretion and authority to alter the recruitment decision. So if you're getting an AI recommendation, the person isn't obliged to follow that. The person has the qualifications and training to disagree with the tool's recommendations or predictions and the ability to overturn them. Where multiple candidates have similar qualifications and experience, the person makes the decision about who to interview, even though they can consider the software's recommendations. And the person doesn't attach disproportionate weight to the tool's recommendations and can take into account relevant data and factors on which the decision was based. The ICO's report highlighted that employers thought their use of automated recruitment tools constituted decision support often rather than decision making. But in practice, they were using tools to make solely automated decisions. They were overly relying on those AI tools and its recommendations. Requiring hiring managers to review scores based on profiling, like on a dashboard, for example, and just to say, these are the recommendations. I'm now going to select, for example, if your AI tool says, we think this is the top 5 candidates, having a hiring manager select the top 5 and push them through to the next stage of the process, that's not good enough to demonstrate meaningful human involvement unless they're genuinely looking at, considering, assessing those recommendations themselves. The ICO said it frequently saw evidence suggesting hiring managers were unlikely to review the scores or responses, particularly of lower scoring candidates. And the ICO expressed concern that employers could not consistently demonstrate how they'd mitigated the risk of hiring managers relying disproportionately on scores when faced with a high volume of applications. And there was an inconsistent approach to meaningful human involvement as between candidates, depending on the AI's assessment of quality or likely success. So what the ICO was seeing was where the AI's recommendation says, look, these are the top 5 candidates we think. These are the next 5 candidates we're not sure about. We think they come below that. Here's 25 candidates we don't think meet the requirements. You're just seeing recruiters just accepting that those bottom candidates, wipe them out, that's it, eliminated from the process. And they just accept that and focus their time and energies on the top 5 or the top 10, where you've got the ones that the AI thinks are most relevant and the ones that are maybe relevant. but rejecting someone is still capable of being a significant decision. It needs human consideration. So the ICO says a process where a recruiter goes through all the scores and profiles, including the responses, to weigh up the tool's recommendations, with access to additional factors in making their decision, maybe the CV, maybe a covering letter, and then makes a final decision about whether to progress or reject each candidate from the process. That is what's required to have meaningful human involvement. So the ICO emphasises meaningful human involvement in each decision about each candidate at each stage of the recruitment process. If you're going to use special category personal data, so health, racial or ethnic origin, sex life, sexual orientation, those kinds of things, for example, there are additional restrictions on using automated decision making. That requires explicit consent for it to be necessary for entering into or performing a contract, or required or authorised by law, none of which are likely to apply in the context of the recruitment process. So you shouldn't, in reality, be using special category personal data. What you want to look out for is that while you may not think that you are making these decisions based on special category personal data, because, for example, if you do request diversity information and that's kept separate, AI tools can and have been found to infer information. So, for example, based on someone's name, maybe where they studied, the language skills they have, any extracurricular activities or hobbies, AI will make inferences potentially about that information and what that means about the individual, and then use that information to support its recommendations. That's something you need to be really aware of. So making sure you understand how systems work, what information they rely on, what safeguards are in place to prevent them using information they shouldn't be using, doing testing to see how this is actually operating are important. But if you are doing solely automated significant decision making, then you need to put safeguards in place. You need to provide people with information about the decisions. You must enable them to make representations about those decisions. You must provide for human intervention on request, and you must enable decisions to be contested. What information do you have to provide? The ICO says you must inform them if you're using their data for automated decision making with legal or similarly significant effects. So we've discussed that already. That's already a requirement under Articles 13 and 14 of GDPR, and if they make a subject access request under Article 15. You must provide meaningful information about the logic involved and likely consequences. Again, that was already the law anyway. In relation to this safeguard, the ICO says information to be provided should include how you're using the tool to make decisions, how accurate the tool is, and what safeguards are in place. That's new, relatively recent, just last month, something the ICO is saying that's where they think the line is, that's what they're looking to see. Merely saying a screening process may be automated in a privacy notice, that's not good enough. Nor is requiring candidates to refer to your length of the general privacy policy or the tool provider's privacy policy. They won't be good enough either, the ICO says. That's not going to comply with the transparency principle or the safeguard of the right to be informed. The ICO recommends that you either use layered privacy notices, provide candidate recruitment specific notices, or just-in-time notices. And the ICO has called on controllers to make sure you're explaining data subjects' right to recourse. In relation to solely automated decision making, that's another area where they haven't seen. The other thing to remember, of course, as well, is that from June, data subjects are going to have the right to complain directly to controllers. And so you're going to have to tell them about those rights too in due course. One thing that the ICO's report doesn't address is the effectiveness of these safeguards, and whether in practice candidates either have been able, whether under the old rules, or they anticipate candidates will feel able under the new rules to exercise these rights without feeling at risk of an adverse impact. On the screen now is just a flowchart we prepared demonstrating how you make your decisions under the new rules. So identifying and mitigating the risks of bias and discrimination. We've talked about how that can impact on fairness under the Data Protection Act, but you've also got obligations under other laws. Section 39 of the Equality Act prohibits discrimination in the course of recruitment in relation to the offer of or rejection from employment and the terms on which it's offered. Discrimination is prohibited on the grounds of protected characteristics, and bear in mind they differ from what constitutes special categories of personal data. Protected characteristics are age, disability, gender reassignment, marriage and civil partnership, race, religion or belief, sex and/or sexual orientation. And employers also have a duty to make reasonable adjustments for disabled people. Human Rights Act 1998, Articles 14 and Article 8 prohibit discrimination in connection with the right to private and family life, which would include on the grounds of certain protected characteristics. So how are you looking to comply with these? You should be conducting an equality impact assessment prior to engaging a third party and their tool and using that tool. You could do that independently or in what we tend to do in connection with AI projects that involve the analysis of multiple risks and multiple bits of legislation and regulatory requirements. We conduct a modular but overarching AI impact assessment with modules that address data protection, equality, human rights, depending on your organisation's obligations and values. We might also address kind of sustainability and other things. But as these issues are all pretty much becoming more and more intertwined and they interrelate, looking at it holistically can be very helpful. You'll want to conduct assurance in relation to AI tools. As we said, AI tools can infer information. Are they inferring age from university attendance dates and preferring younger candidates? Are they in fact inferring ethnicity or religion from a name or a school someone attended? Just as for data protection, you're going to need to test this, and that's going to be based on information obtained from the developer or your own testing. What might that testing look like? You might run a range of testing. You might be running side-by-side comparisons of AI versus human-assisted or AI-driven decisions and literally doing the same recruitment campaign 2 ways and then comparing what that looks like and trying to understand where there were differences and how they came about. You might want to test a system with dummy data to check the output, and you'll absolutely want to be doing ongoing monitoring to see how systems are delivering. You also need to be aware that, as we said, candidates with disabilities or neurodiverse individuals may be particularly impacted by certain AI tools in recruitment, like tools that aim to infer emotions or personality types, and you'll need to consider whether you ought to be offering reasonable adjustments in relation to those. AI governance. Now, the UK's responsible AI principles, there are 5: safety, security and robustness, appropriate transparency and explainability, fairness, accountability and governance, and contestability and redress. These are not mandatory, although you'll note that a lot of them reflect things we've already talked about in terms of requirements, either under data protection law or equality law. But it's worth noting that if you're going to comply with these measures, which responsible business would require you to do, they apply more broadly than merely where the restrictions on automated decision making under the GDPR apply. So you need to bear that in mind. But it will support, if you comply with it, it will support your compliance with your wider legal obligations in all circumstances. It's worth noting that other global responsible AI frameworks are potentially more expansive than the UK's version. So, for example, the UNESCO recommendation on the ethics of AI also incorporates principles of sustainability, do no harm. Human oversight is a requirement. So again, that would go much further than what the UK GDPR requires. And also there is a requirement for literacy. While the UK doesn't have an explicit requirement for AI literacy, and nor does data protection law, the ICO's requirements for individuals to be able to exercise meaningful human involvement around, understanding how the system works, applying their own judgments, etc., that will necessarily require a foundation of AI literacy. So making sure that if you're going to use AI, your organisation is also thinking about responsible AI governance is really important. So, look, what happens if you're not complying? Well, you're probably not getting the job done. You're not going to be identifying and appointing the best person for the job. You might be unlawfully processing personal data, unlawfully discriminating against people. It's worth noting the ICO has already engaged with 16 entities and required them to implement remedial measures to comply with data protection legislation. And the ICO has said that is not the end of its enforcement in this area. So you'll have regulatory exposure. You're exposed to potential litigation. There's the risk of adverse reputational impact. You may fail to comply with your own corporate values, and there may well be a breach of trust and confidence, not merely between employer or recruiter and candidate, but also between employers and existing or new employees. It's also worth noting that the ICO has published guidance for candidates on the use of AI, so people are likely to become more aware of what should be happening, what good looks like, and what their rights are in this context. The ICO said we continue to engage with developers, employers, and wider industry to provide regulatory clarity. Will not hesitate to take further action if we consider it necessary. And again, you've also got the future complaints coming into force with effect from June. So you might have to deal with more complaints, and that's going to have an impact on resources. So we get to the point now where we're going to look at some case studies. So case study 1. AI is used to sift applications to confirm whether participants hold specific mandatory minimum qualifications or meet mandatory requirements, such as having the right to work in the UK. We touched on this already. That's not a decision for the purposes of the UK GDPR. It's the application of binary rules. It doesn't fall within the definition of a decision which is a conclusion or outcome reached after consideration or analysis, which may impact or influence actions taken or engage a data subject's rights. As such, you still have to comply with your general data processing requirements, equality law, other obligations, but this is not a restricted, solely automated decision that you need to have safeguards, the specific ADM safeguards in place for. Case study 2. You use an AI tool to score competencies and skills in CVs or to rank candidates to identify candidates for shortlisting for interview. Low-ranking candidates are automatically rejected from the process, but there's no communication to candidates of the outcome. Well, this would be a decision for the purposes of the UK GDPR because it's a conclusion or an outcome reached after consideration or analysis, which may impact or influence actions taken or engage a data subject's rights. In relation to those candidates who are rejected, that is a significant decision because there has been an equivalent impact on their opportunities. There is no human involvement in the significant decision here because the rejection is automatic. There's no communication to affected individuals to tell them that they're being rejected. They're just left in limbo. But because of that, the safeguards aren't being met. They aren't being told what their rights are. As such, there will be unlawful processing of personal data here as a consequence of the failure to comply with the restrictions on solely automated decision making set out Articles 22A to D of the UK GDPR. There may also be further breaches of the law depending on how the profiling underlying those AI recommendations that have then become decisions because they're being automatically acted upon have been undertaken. However, to contrast, if every AI recommendation was reviewed by a recruiter who took into account the scores, other available information, maybe a CV, covering letter, to decide whether or not that AI recommendation ought to be accepted, they genuinely exercise their own judgment. There is evidence that over time they do override on occasion AI recommendations. There would be meaningful human involvement and no solely automated decision. So there still wouldn't need to be safeguards and there would be no obligation to then communicate to the individual that they have the right to human intervention and those things because you've already got it. So the failure to communicate the outcome to candidates wouldn't become an issue. Case study 3. An AI tool is used to score competences and skills in CVs or to rank them, so as per the last case study, which ultimately leads to decisions as to candidate rejection. Low-ranking candidates are automatically rejected from the process. There's no communication to candidates of the outcomes as before. The difference in this scenario is it was the hiring manager that prompted or set the parameters for the AI tool to determine the scoring. Is that sufficient to constitute meaningful human involvement? The ICO says no. Setting parameters or human involvement in setting parameters isn't sufficient to constitute human involvement, so there would still be a breach of the rules here. And final case study. AI is used to detect emotions or evaluate language, tone, and content in a video interview to predict personality type and determine best fit for the team and organisation, with only high-scoring candidates progressing to the next stage of interview. Rejected candidates are notified and informed of their rights. This would be a decision for the purposes of the UK GDPR. And in relation to rejected candidates, it's a significant decision because it has an impact on someone's opportunities. There is no human involvement in the significant decision in relation to rejected candidates, because that rejection is automatic and therefore there is a solely automated decision here. However, because the candidates are being communicated with and told of their rights to request human intervention, to challenge the outcome, then the safeguards are in place. But notwithstanding the fact that the automated decision-making rules would have been complied with, emotion recognition technology is not proven and risks inaccuracy, bias, and discrimination, as does the evaluation of language, tone, and content to infer data about people. The processing still risks being deemed to be unfair, data processed to be inaccurate, and or for there to be breaches of equality legislation. So you need to be very careful in this kind of context of making sure that you're complying with your wider obligations, even if you're meeting the strict requirements for automated decision-making. Our email address is at the bottom of your screen, info@handleygill.com. You can follow us. We're on all the social media. We're on X, Blue Sky, Threads, YouTube, where this video will be uploaded after the session. We're on LinkedIn. You can also subscribe to our monthly email newsletter, and you can access our website at handleygill.com. Thank you very much indeed for joining us today. As I said, my name is Nicola Cain. I am the CEO and Principal Consultant at Handley Gill Limited, an award-winning legal and regulatory compliance consultancy specialising in data protection, responsible AI governance, content regulation and online safety, responsible business and human rights. If we can help you and your organisation get the job done right when it comes to using AI in recruitment, please do not hesitate to contact us. As I said, you can contact us at info@handleygill.com. Our details are on the website. You can also request an appointment with me via the website. Thank you very much for joining us today. We hope you found today's session useful, and we hope to see you again at a future event. Thank you.